Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. In the last episode, we learned how the Act provides us with an option to oppose grant of a patent in its application phase, the pre-grant opposition. But what if we miss an opportunity to oppose the grant of a patent in its application phase? Do we have to live with the patent forever? Or do we have an option to oppose a granted patent as well? Before discussing that in detail, let's visit the playground again. We have an actor who is involved in research and development or manufacturing or sale of a product which pertains to a technology or invention on which a patent has been granted. Now you have guessed it right. If he were to continue with any of these activities, all these activities would be considered as infringing activities. It's not a happy place to be in. He's utterly disappointed as he would want to continue with his business activities. So what options does he have? Can he oppose a granted patent? Fortunately, Act provides us with an option to oppose a granted patent as well. But not anybody and everybody can file an opposition for a grant of a patent. Only person interested, Section 21T, can oppose a granted patent. That too within 1 year from the date of the grant, as per Section 25.2. Now, as discussed in the previous episode, while we prepare for such an opposition, we need to come up with valid reasonings and substantiate them with appropriate documents and evidences. Now, what reasonings can we think of? Again, revisit the last episode. We took assistance from all the sections which define technical and procedural requirements for a patent to be in order for grant. We use the same sections to find discrepancies with which a particular patent application was filed with the patent office. Let's revisit those. So Section 2 and Section 13 defines the technical and procedural requirements. If there are any discrepancies or shortcomings that we can use as a ground to oppose the grant of the patent. So we can choose one or more of such grounds and provide necessary arguments and collect necessary documents to support our opposition. Now, once we are ready with the package with our arguments and with supporting evidences and documents, we approach the controller. As per Rule 55A, we use Form 7 to provide notice of opposition to the controller, along with clarifying our position, how we are person interested, and providing our statement, our arguments, and all the supporting evidences. We are also required to provide a copy of such a notice of opposition to the applicant as well. Once the controller receives the notice of opposition, as a next step, the controller notifies the applicant as well as constitute an opposition board. See, this is where it is different from pre-grant opposition. There was no opposition board there, but here an opposition board is constituted by the controller. Now let's look at the details of such an opposition board. Basically, it's a 3-member committee. One of the member is appointed as a chairman. Now you may wonder who could be eligible to be a member for this committee. Among other members, a person who is appointed as an examiner at the patent office can also be part of such a committee. Not the examiner who actually examined the patent application in question, but anybody else who is qualified to be an examiner can be part of this committee. Now, this committee goes over all the documents that are provided by the parties, the replies, the responses, the evidences, and provide their recommendation to the controller with regards to what do they think about this particular case. Moving back to the timeline. Now, since this is an opposition proceeding, Rule 57-63 gets employed, where we have replies, responses, documents, and hearing. Once such hearing is concluded, parties again would submit written statements to the controller. Controller goes over the replies, responses, documents, written statements, and also the recommendation of the opposition board before coming up with a judgment or decision. What that judgment could be? The notice of opposition can be accepted or rejected. Accordingly, the patent could be revoked, amended, or maintained based on the recommendations of the opposition board and arguments made by the parties. Now, in case when a patent is revoked, it's revoked for good. However, if the patent is amended, then the amended patent would be in force with whatever amendments with regards to the claims that have been done by the patentee. This brings us to the end of this episode. In the last 2 episodes, we learned how grant of a patent can be opposed both in the pre-application phase and after the grant of the patent. The difference being anybody can file pre-grant opposition. However, only person interested can file a post-grant opposition. Another difference being pre-grant opposition is filed before the grant of the application and post-grant opposition is filed during the first years from the date of the grant of the application. In the next episode, we will discuss a scenario where the pre-application phase has passed the first years after the grant have also passed. Is there a way I can revoke a patent after the expiry of first year as well? So I'll see you in the next video. Till then, be good and take care.